firm's name is Anderson Terpening. The thing that our firm specializes in is litigation disputes. And traditionally, when companies or individuals ran into trouble, the typical reaction was to go and seek assistance from only large firms because that's where the quality was and that's where the experience was. And we've assembled a firm about 2.5 years ago that is designed as a boutique litigation law firm to handle the full spectrum of business and individual high-stakes disputes. We focus on prevention and compliance to try to keep companies out of trouble, let them benefit from some of the lessons that our clients and others have learned the hard way. And we also try to represent them in the agency regulatory arena, as well as civil litigation, criminal litigation, and appellate and even mediations. We have 4 lawyers who have not only experience in different areas of law, but also experience in trying cases. And oftentimes lawyers may have the substantive expertise, but they're always hesitant to get into the arena. The courtroom for us is kind of a natural extension of that process. Whenever we represent a client, we always try to master the facts to understand what led to the dispute with an eye towards resolving it. You then have to research extensively the laws and regulations that apply, but you also have to reach across to your opponent and get a sense of what's motivating them and what caused the water to heat up and how hot is it. The trends that we've seen in the last 10 years is many disputes that a decade ago would never have gone outside of the regulatory or civil arena are being ratcheted up for criminal prosecution. And so oftentimes the clients that come to us have never been in trouble before. And it's hard for them to understand, why am I looking at jail time when I'm not a bad person? And they're bringing, unfortunately, outdated notions of what federal crime means. It's not rape, robbery, evil-heartedness. It really is ground rules and regulations that can be very difficult and complex to understand. So when you add the whole combination of a difficult regulatory criminal environment that's not intuitive or obvious, and then you throw on top of that mandatory jail time, it's a disaster. Over the last 13 years, I've been on the defense side in private practice at a variety of firms. And there's not a day that goes by in defending clients that I don't draw upon my experience as a prosecutor. And I often use the analogy, you really need to best represent the client. You need to be able to open up your opponent's playbook and understand how they're going to interpret certain facts and truly understand how much leverage and how do you influence the broad discretion that a lot of prosecutors have. I think the hardest part in doing what we do, the stakes are so high for the client. You often meet them at a time where they're under incredible stress. That's both challenging and rewarding. There's no question when clients come to see us that it's usually externally driven. They've either been indicted or they've been sued, and they don't want necessarily to be here. So half of our role is to actually focus on the legal issues, but you also have to bring kind of a human touch and to be able to communicate and convey genuine concern. The other problem is the clients just want you to make it go away. And when you see the kind of pain and struggle that they go through when they're being investigated, only someone who has no sense of compassion could be comfortable with that kind of struggle. You see marriages being strained, you see kind of personal reputations and professional reputations being taxed. On the professional level, the most rewarding is getting a case that looked as though it was about to be indicted and getting that declined. Having the prosecutor gather information and reach the right decision and give the client their life back. To me, there's nothing more rewarding than lowering the fees and bringing that peace of mind and sense of security and allow them to get on with their lives. Short of that, when we try to negotiate and the prosecutors won't listen, a close second is having a jury come back, which we've done frequently in this case, and with a not guilty verdict, and to demonstrate that our sense of perception of the facts was the right one. That often helps in future negotiations with the prosecutor, because they know that you are going to be prepared, you are objective in your assessment of the facts, and you can communicate effectively with a jury and make them want to rule, despite all the power of the federal government and your opponent, to rule in our favor. And that just comes from experience and preparation and hard work. We often take cases on a flat fee that's grossly below what our rates are. When it's the right case and we feel like the client deserves that shake, we often take cases on through the court-appointed system, where we receive a very nominal fee from the court, often because the client fits a certain criteria where we think they've been wronged and they deserve the best representation. So we're also committed to pro bono service and really civic involvement, whether it be the Kiwanis or whether it be the Bar Association or whether it be our church and other organizations. I'm very active in the domestic violence victim advocacy, the local organization. That's where you can change the perception that lawyers really don't care about people, they just care about their bottom line. There's always going to be bad actors in every industry. We're very proud of what we've been able to demonstrate, both in the clients we represent as well as the community activities that we get involved in. One of the biggest mistakes that I've found watching other lawyers is they do the talking way too much when it comes to learning the client's business, learning about what's motivating the dispute, and actually learning about how to get a more effective, stronger defense, which is ultimately going to get more favorable results in negotiation or trial. But it really is, to hire the right trial lawyer, you have to have all of those skill sets. You have to be an effective writer. You've got to be able to communicate in the written form as well as in the verbal form. Oftentimes, if you write in the civil context an effective motion to dismiss, that makes the case go away if you've been sued. You can't put a price on that. A lot of times people check the box. If they're poor lawyers, that's the challenge of the purchasers of legal services. It's hard, if you're not in the profession, to understand how to evaluate someone in that profession. But it really is, you've got to find lawyers who have the characteristics, all of the characteristics that are required for an effective defense, without a preconceived notion about which way this case is going to go before they even climb up the learning curve. And all of our lawyers have a similar mindset and a culture here of experience is the most important attribute, intelligence, work ethic, camaraderie, communication, and that's more important than anything else, because that's what drives the client referrals. It's very much of a relationship profession, and we attribute a lot of our success not only to the natural kind of attributes, but the personality of the firm, as well as how we treat our clients. Win, lose, or draw, every client of Anderson Terpening feels as though we cared, we worked hard, we weren't surprised by any development, and we stood by our clients and fought as hard as we could. And it's brought tremendous results, both for the firm's success, but as well and more importantly to the outcome for our clients.